Welcome, everyone, to today's American Health Law Association podcast, where we'll be talking about key healthcare fraud and abuse issues to watch for in 2025. Today, my guest is Ilene Albala from Goodwin Procter. Ilene and I have collaborated on a handful of webinars in the past, and she always brings great perspective on healthcare fraud and abuse trends, especially trends related to the False Claims Act and litigation and investigations related to the False Claims Act. Ilene and her colleague, Jordan Morin, recently authored the Fraud and Abuse Issues to Watch section of the top 10 issues in the January-February edition of the AHLA's Connections magazine. It's a great read. It's always a good read, but this one in particular really captures the evolving issues that are emerging in healthcare, and it's as active as it's ever been. And so the article is excellent. Today's podcast is brought to you by the American Health Law Association's Fraud and Abuse Practice Group. I'm in my final year of chairing the practice group, and our mission is to help our members stay informed about healthcare fraud and abuse and compliance issues. So we focus on developing webinars, publications, and other content to educate our members on important compliance developments and enforcement trends in the healthcare industry. If you're not a member of the practice group, please consider joining us. We're always looking for new members and new energy and ways to get new people involved. But before we get started with the back and forth with Ilene, could you go ahead and introduce yourself?
Yes, thanks so much, Joe. I'm delighted to be here with you today. So as you mentioned, I'm Ilene Albala. I'm a partner at Goodwin Procter in our Washington, D.C. office. And here in our nation's capital, as you mentioned, Joe, we have a lot going on right now. So my practice focuses on healthcare and life sciences, government enforcement, and False Claims Act defense. Prior to joining Goodwin, I was an assistant U.S. attorney in the Eastern District of Virginia, where I investigated healthcare fraud. And today, I help clients navigate the alphabet soup of enforcement and regulatory bodies in the space, from DOJ to HHS-OIG to the FDA, DEA, and so on.
Great. Again, thanks, Ilene. And my name is Joe Wolfe. Again, I chair the AHLA's Healthcare Fraud and Abuse Practice Group. I'm a shareholder at Hull Render, and I lead Hull Render's Healthcare Regulatory Practice Group. My day-to-day work focuses on physician compensation arrangements, Stark and kickback compliance. I do a lot of work in the new value-based enterprise space and in government investigations, and do that work nationally. And love the opportunity to collaborate with someone like Ilene today and learn from her as well. First of all, I already touched on this, but great job on the Connections article. If you pick up that article, anyone listening in, it highlights the top 10 issues in health law for 2025. In the article, Ilene discussed really, and I, again, don't want to steal her thunder, but how the next 4 years could reshape the healthcare fraud and abuse landscape. And I agree with her on that. For years, we've been combating healthcare fraud, and that's been a critical priority. That's been a critical priority of the DOJ. Now it's a bit of wait and see on whether that remains a priority, and I think Ilene's going to speak to that. There's some uncertainty. Our current administration now could shift enforcement priorities and cut and reallocate resources. There could be a remaking of the legal and regulatory landscape now with Robert F. Kennedy as the new Secretary of HHS and Dr. Oz leading CMS. There's obviously opportunities for a change, and likely will be change. And as Ilene talked about in the article, healthcare fraud and abuse enforcement is largely driven by the False Claims Act, and its key TAM provisions and evolution there is a big topic. Relators are still driving enforcement in this space, and as we'll discuss, there's been an uptick in investigations, and everything we're seeing just speaks to and previews a really active healthcare environment related to the False Claims Act. And so I think a lot of the discussion we're going to have today is going to be focused on the False Claims Act. And we will touch on some other developments, but that's why I'm so excited to have Ilene to talk to today. So Ilene, let's go to the first question here. it does timestamp us a bit. We're a few days into the new Trump administration now. As you look at 2025 and beyond, what are you seeing so far, and how might that impact the enforcement space and how the False Claims Act is handled in particular?
Yeah, thanks, Joe. So I think the word I would use is whiplash. There's a lot going on already. And, for context for the viewers, I served at the Department of Justice under three administrations: Obama, Trump, and the first chunk of Biden. And the second Trump administration already feels very different. And I think our viewers are sensing that as well. So the biggest change that I'm seeing is that, we're barely a week in, and there's already a real flurry of activity. That speed was not there during the first administration. And a lot of that activity appears to be aimed at thinning the federal government, and namely shrinking the DOJ, or at least certainly shifting its priorities. Anecdotally, I know several prosecutors who are already receiving letters asking them or telling them to leave, or shifting their work from one area of DOJ to another, such as immigration, for example. So what does all of that mean for enforcement in the fraud and abuse landscape, and specifically for False Claims Act enforcement, which I follow quite closely, as you mentioned? So again, we're only, days in, so some of this is speculation, but the natural consequence, of course, of a significantly smaller DOJ, at least from a fraud perspective, it's going to result in cases that are either not brought, or investigations that really linger. I do think you're going to see a situation where, and I know I've discussed this with many of my current clients and past clients as well. There is often frustration at the speed. These cases can take quite a lot of time, and so I do have a number of questions. If and when we lose trial attorneys and AUSAs, line attorneys who are working on these cases, what does it mean? I do think that cases that are still a high priority for even this administration from a fraud and abuse perspective will likely continue to remain that way. But I do think that we'll see some sort of not insignificant impact on investigations that are ongoing right now. The Senate Judiciary Committee is voting right now, and that really does date us a bit. But they're voting right now on Pam Bondi's nomination to be Attorney General. I think it looks like she will be confirmed and be our next Attorney General. But I did want to highlight that because Senator Grassley presided over her nomination proceedings, and perhaps unsurprisingly to those of us who are really familiar with Senator Grassley's outspoken role with respect to the False Claims Act, he was really focused on this during her proceedings. And, of course, Senator Grassley is considered to be the architect, right, of the 1986 FCA False Claims Act amendments. But nonetheless, it really was quite notable that, he focused her on the False Claims Act and these questions in that first, hour of her 5, almost 6, plus hour confirmation hearing. So it took up space and early on in those hearings. And he asked her specifically about her commitment to defending the constitutionality of the False Claims Act if confirmed. She responded that, of course, she would defend the constitutionality of the FCA, that she understands the importance of whistleblowers, the FCA's protections, and in her words, the quote unquote money it brings back to our country. And indeed, it has brought a significant amount of money back to the US. It was interesting, however, and I went back and replayed this back and forth between Senator Grassley and Ms. Bondi. And it was interesting to note that he also asked her specifically if she would ensure the appropriate staffing and funding levels necessary to prosecute False Claims Act cases. And that's a question that she didn't directly address, at least not that part of the question. So I think at the end of the day, Joe, time will tell.
Great, and thanks for that really thoughtful answer. Ilene, aside from his legacy and history with the False Claims Act, from your perspective, why would Senator Grassley be so interested in understanding the new Attorney General's views as to defending the constitutionality of the FCA? What do you think's happening in the current case law that would bring doubt to the constitutionality of the False Claims Act?
Yes, no, that's a great question, Joe. So, Senator Grassley's question to Pam Bondi during her nomination hearing, it was not merely an academic question asking her about the constitutionality and whether she would defend the False Claims Act. It's quite timely. So on September 30th of 2024, a federal judge from the Middle District of Florida issued a groundbreaking decision invalidating the qui-tam provision of the False Claims Act. So this was the decision in Zafarov that found that a relator bringing a qui-tam suit qualifies as an officer of the executive branch who is improperly appointed in violation of the Appointments Clause of Article 2 of the U.S. Constitution. Over objections from the government, which actually had declined to intervene in the underlying qui-tam, the court dismissed the case with prejudice on the basis of its constitutional holding. So this decision will likely be appealed to the 11th Circuit and could ultimately be decided by the Supreme Court, which we're all watching. I'm certainly watching because 3 justices in Polanski, Justices Kavanaugh, Barrett, and Thomas have already questioned whether the False Claims Act's qui-tam provision violates Article 2. So I fully expect to see companies, defendants raising this issue in qui-tam suits from here on out. So his question is quite timely. Let me ask you a question for a second, Joe, if that's okay. So I know that you do a lot of work in the anti-kickback and Stark space, and you mentioned the appointment of RFK Jr. and Dr. Oz. I'm curious to know, do you expect them to remake the kickback or Stark regulatory landscape? What are you watching in this space?
Yeah, thanks, Ilene. And we are mostly here to listen to you, but I'm happy to answer a couple questions as well. This is not the first Trump administration, and so we have witnessed already how the first Trump administration handled the Stark Law and the kickback statute, and in many ways, they did not look at scaling it back. They actually revamped it and built in some very innovative components related to value-based arrangements. And so when I go back in time and I think about the last administration, if that's the most telling future, we saw innovation under the Stark and kickback. We saw a relaxation of some of the more rigid components of the Stark and kickback exceptions and safe harbors to provide a bit more flexibility, and that was very welcomed that last time around. And so, I'm hoping we see more of the same. An interest in innovation, an interest in finding ways that we can transition payment models and how healthcare contracting aligns with concepts like care coordination and enhanced quality and cost savings to payors, whether it's the government or private payors, to transition us from healthcare payment and delivery based on volume towards value. So, that's what I'm hoping to see from a regulatory standpoint. I do think from kind of at the ground level, because of the ongoing pipeline of FCA cases involving Stark and Kickback, we're going to continue to see these cases being unsealed just along that normal pipeline. We continue to see that. We've seen some large settlements, especially in my area around physician compensation arrangements. I think we will continue to see that as well. And so we kind of hopefully are seeing innovation on the regulatory side, and then maybe more of the same on the enforcement side. I say that because there has been no slowdown in government investigations. Everyone I'm talking to and in my own experience is seeing a steady stream of CIDs and investigations still continuing. We'll see how that's impacted by the change in administration, but because of that kind of lag time on the pipeline of cases, I think we'll still see that. So appreciate the question. I think we could wrap up maybe with a final question for you, Ilene. Do you just have any final thoughts for our audience and looking back at 2024, looking forward to 2025, some things to watch out for, or just some final thoughts?
Yes, no, I appreciate that, Joe. And I did want to also pick up on something you just said, which is that lag time, and that's absolutely the case. So as long as the False Claims Act remains constitutional, I think that we will absolutely continue to see enforcement in this space. And the reason is you will have relators, right? You'll have these key TAMs that will just continue, and they continue in number. So they're not going away, and the judiciary is not going to let them sit there. Now, some districts let things linger for longer. I come from EDVA, from the Rocket Docket, where, as an AUSA, we had no more than 9 months to investigate even the most complex of healthcare fraud matters. Some districts, they sit for longer, but the bottom line is they need to keep these moving, and you have a very large and sophisticated plaintiffs bar, relators counsel, who will continue pushing these. So even if we see a slimmed down version of civil frauds, for example, I think we absolutely will continue to see these investigations. And to your point on the lag time, they take years to move forward, to investigate, to come to a resolution. And we have seen a record number of civil investigative demands issued in this past year. And so that process and those investigations will continue to play out. I just think that, if you have only, one attorney working on, hundreds of cases, I just think the natural consequence is that I think we probably will see some that will linger, but time will tell. Enforcement will continue, absolutely. I would also just say that on the False Claims Act front, let's also not forget just yet about super value. So you've heard me say this before, Joe, but while I don't believe that the Supreme Court's recent decision in super value was earth-shattering, the full impact of that decision is really still playing out. And the big takeaway here, from my experience dealing with DOJ, is that they seem to view super value, conveniently, as a way to apply additional force, additional pressure during the negotiation stage. And indeed, a subjective scienter standard is more likely to present questions of fact for a fact finder, potentially making it more difficult to defeat FCA claims early in litigation by challenging the sufficiency of plaintiffs' scienter allegations. And so that's an area that we're watching quite closely as well. But so much going on in this space, and such a pleasure talking with you today, Joe. Thank you.
Great. Thanks, Ilene, and thanks, so much for your time today. I know it takes, you do have to, take time out of your day, but also prepare and try to synthesize everything going on into a short discussion. And I really, really appreciate that. I appreciate everyone for listening in to today's podcast as well. We're always looking for volunteers within the AHLA Fraud and Abuse Practice Group. Please reach out to me on LinkedIn if you'd like to be a guest in a future episode. We have a couple in the pipeline, but we're always looking for more. Watch for recent podcasts that we've published. We have a couple of, like I said, future podcasts in the pipeline. Watch for those as well. We'd love to get you involved. We'd love to get you in the mix. Thanks again, Ilene, for being here. Thanks everyone for tuning in, and have a great day.
Thanks so much.